Hi, this is Brian Weekley of Snow Carpio and Weekly. I wanted to talk a bit about common misconceptions in workers' compensation. I'm just going to kind of freestyle this and throw out some things that have come up repeatedly in my 32 years of doing this type of law. Number one, in workers' comp cases, there is no pain and suffering paid. There are no damages paid by statute. You receive only two types of benefits. Those benefits are medical benefits, which are paid with no copays, no deductibles, and then compensation benefits, which are also called indemnity benefits, which you know as money, and those are a percentage of your average monthly wage. Those are meant as partial wage replacement. They're not taxed. There are no damages. There's no claims for, again, pain and suffering, loss of earnings, and other things. This is a statutory system with only two types of benefits paid. There is an exception for bad faith claims if an award is issued, but those are pretty rare. So that's point number one. Point number two, people ask me a lot, will it hurt my case if I go back to work? And the answer is no. I think it helps your case. If you're on modified duty and you find a modified duty job, or if you're stationary and you have limitations and you find a job within those limitations, that helps your case. That's what the system is supposed to produce, is you're returning to the labor force. Judges and doctors like to see that. It means that the system is working. It means that treatments are working, etc. So that's always a good thing. Number three, and this is a big one, people ask me probably at least once or twice a week, can I sue my employer in negligence? The answer is no. Workers' compensation is a no-fault system. It doesn't matter whose fault it is that you get hurt. All that matters is you had an injury and that occurred arising out of and in the course and scope of employment. If you establish that and you have coverage, you're entitled to, again, two types of coverage, medical benefits and cash/indemnity benefits, and that's it. You cannot step outside and sue your employer in negligence, except for very rare cases. Number one, if your employer is uninsured, you can make an election to sue them in negligence. I've not seen that done in probably 20 years in one of my cases, for whatever reasons there may be. Number two, if your employer intentionally injures you, and we have to show intent, which I've never seen in my 32 years, you can step outside the system and make an election. When you make an election, though, you're electing the civil remedy over the comp remedy. Sometimes the comp remedy is far superior, given the balance of things and the risk of a civil action. Sometimes I imagine it can go the other way. But in general, you cannot step outside and sue your employer in negligence. Point number four, what we call third-party cases. What if you work for X corporation and you're injured while employed by X corporation, but it's the fault of Y corporation, not associated with X corporation? You have two claims. In that case, you have a workers' comp case, and you have what we call a third-party case or a civil claim against Y corporation that you can pursue. And that's done with a separate lawyer. For us, it's a lawyer that specializes in personal injury. These often arise out of motor vehicle claims where somebody's on the job in a car and they're hit by someone else. That's where a third party is introduced into the claim. If you get a recovery from Y Corporation's insurance company, X Corporation's workers' comp insurer has a lien on that. That's the subject of a whole different set of videos I could do on that actually. But that's good to know. So those are four things, really four common misconceptions I wanted to talk about. Hope it helps. Call with any questions.